Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association tells me that I've got to say this, but once I've said it, nothing prevents me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So, off we go with today's episode. Disability carriers can be excessively sneaky. In fact, they often will cherry pick medical records and scrape evidence from files that supports their claims denial, all while ignoring the mountains of evidence that suggest you are indeed disabled. In this episode, I'm going to be talking about three things. First, how Reliance Standards doctors cherry pick medical evidence to justify the denial of a colitis and Crohn's disease disability claim, UNUM's cherry-picking medical records to justify a claims denial in an ankylosing spondylitis case, and how Hartford cherry-picked the medical records when the policyholder doctor said that he was hopeful that the policyholder could return to work in 6 months. You can see that this is a strategy that every disability carrier employs in creating reasons to deny claims. And it doesn't matter who your disability carrier is, there are lessons to be learned from these cases. So let's take a break for a moment before we get started in this week's episode. Welcome back to Winning Isn't Easy. UNUM cherry picks medical records to justify a claims denial in an ankylosing spondylitis AS case. Ankylosing spondylitis AS is a type of arthritis where there is long-term inflammation of the joints of the spine, shoulder, or the hips. Now, disability carriers like UNUM will play games with ankylosing spondylitis cases based on the progression of the disease, the progression of the symptoms, and or the lack of improvement with treatment. Back pain is characteristic of AS, and it often will come and go. This come and going nature of symptoms will often lead a disability insurance carrier to cherry pick the medical records. And what they'll do is they'll seize on these times of improvement where the symptoms are either gone or the symptoms are reduced. Now, we know that treatment for AS consists of non-steroidal anti-inflammatory drugs, immunosuppressive drugs, physical therapy, and even surgery. And I think that the lack of change in this treatment over time, or the lack of change for improvement over time, can play into a disability carrier's denial of a claim. So how does this all add up? Well, let me give you an example. This is the case of Willard versus UNUM Life. And Willard was a production supervisor at Amcor Flexibles until March of 2019. He became unable to work as a result of AS. Now, he had been diagnosed with AS in 2004. He had had chronic pain for 15 years. By 2019, he had pain in all of his joints in his low back. He got treatment from his rheumatologist in April of 2015 and complained of persistent pain in his back and his joints, particularly his hips and his knees. Now, the treating physician noted that Willard had decreased range of motion in his hips and spine, and that was confirmed by objective testing. Now, Willard's pain would increase or decrease in severity, and it did over the course of the years. And there were pain level scales that were used that he was asked to rate his pain with. And that's a whole different issue for another podcast. But using a scale of 1 to 10, 10 being, you're hospitalized, 1 being no pain, he would rated his pain 3 out of 10 in severity in April of 2016. It was as high as 9 out of 10 in April and December of 2017. Now, despite him taking medications and receiving cortisone injections, his pain persisted. But the pain level, as I've said, varied. There weren't any other treatment options that his physicians were presenting to him. On March 8, 2019, he visits his treating physician. He complains of pain in his hips and his knees, and he describes this pain as sharp and burning, and it is a 6 out of 10 on this scale of 1 to 10. Now, his treating doctors note that his pain is relieved with rest and with intravenous administration of Remicade that he gets every 6 weeks. At that visit, Willard got a steroid injection in both knees, and the Remicade dosage was increased. Now, physically, on examination, he had a normal range of motion and strength in his upper extremities, but he had profoundly decreased internal range of motion of the right hip, the left hip, and he had grinding in his knees bilaterally. There was also a decrease in the range of motion of his spine that was confirmed by objective testing. So his doctor suggested that he might want to apply for his short and long-term disability benefits as a result of his ongoing problems. So Willard did just that. And he applied for his UNUM disability benefits that were provided by his employer. So what did UNUM do? Now, here's some lessons for you to learn, regardless of whether or not your disability insurance policy is through UNUM, because this is the game that disability carriers will play in reviewing records and cherry picking medical records. So UNUM had this forum discussion. That's a discussion that disability carriers have. They'll have their claims staff, their medical director, maybe their vocational rehabilitation counselor, and they'll all kind of sit around a round table and discuss the case. And the issue is going to be whether or not you have medical support for your diagnosis, medical support for your restrictions and limitations, and whether you can perform the functional demands of your occupation. Now, when UNUM looked at his records, Willard's records were under the microscope. They noted that he had only seen his treating physician once since March 18, 2019. So there was a gap of about 6 months, that his treatment plan hadn't changed in over a year, that his symptoms and complaints were not necessarily being documented as worsening, but we kind of had this, waxing and waning. His physical exam findings had not changed for over a year, and he hadn't made any new requests for medication. So UNUM had its on-site physician review the file, and of course, UNUM's liar-for-hire doctor opined that the medical evidence did not support a finding that Willard was disabled. And by the way, the doctor suggested that he was, able to work, notwithstanding the opinion of his treating physician otherwise. Now, UNUM had the liar-for-hire opinion reviewed by Willard's treating physician. And his treating physician said, look, I disagree with your liar-for-hire opinion. I'm the treating physician, and I think you need to go get an IME, which of course UNUM didn't do. Now, UNUM denied the claim on the basis that he had the ability to perform activities of daily living. He could launder, he could do the grocery shopping, he could drive, and allegedly that was inconsistent with his ability to perform his own occupation. And of course, they cited the fact that his treatment hadn't changed over a year, that he hadn't seen his treating doctor in 6 months, that his symptoms and complaints weren't documented as worsening, they hadn't made any new requests for medication, and that the physical exam findings had remained the same. But they weren't done here, creating reasons to create the claims denial. So they meaning UNUM, had the file reviewed, but this time they had it reviewed by a rheumatologist. And the rheumatologist, of course, another liar for hire, said, I agree with this denial. And look, Willard was able to work full-time prior to his last day. There's no evidence of a flare-up around the time of his claims denial. There's no reason that I can see, looking at these medical records, that would justify his doctor's instruction that he stop work and apply for benefits. Now, this case obviously ended up in federal court, and Willard argued before the judge that the denial was what's known as arbitrary and capricious because UNUM had failed to have Willard physically examined, that they had relied on its in-house file reviewers' credibility determinations about his activities of daily living and whether they were consistent with his vocational activities, that they had relied solely on their liar-for-hire doctors, and that they had failed to meaningfully evaluate the medical evidence. So ultimately, the question that a federal judge has to face in these cases is, one, what's the standard of review? And two, what am I going to do with this case in view of that standard of review? There are two possible standards of review. There's what's called the de novo standard of review, and there is what's called the arbitrary and capricious standard of review. A de novo standard of review gives the federal judge the opportunity to re-review the evidence and not be bound by the carrier's decision to deny or terminate benefits. So they bring their own independent judgment to the case and the facts of the case and reach their own independent decision. In the case of arbitrary and capricious, the issue is not so much whether or not the decision is right or wrong, but whether or not the decision to deny the claim is what's called arbitrary and capricious. And what you and I think as being arbitrary and capricious is not always the case. So in this particular issue, the federal judge was faced with a question as to whether or not UNUM's decision was arbitrary and capricious, because that was the applicable standard of review in this case. So Willard argued, look, the failure to have an independent medical evaluation is arbitrary and capricious. What did the judge do with that? Well, the judge noted that that was certainly a factor in deciding whether or not this decision was arbitrary and capricious. It doesn't necessarily mean that the decision to deny the claim and not to get to the IME wasn't right. Doing a file review is just one way of making a decision. And while the carrier has the right to have an IME, they don't have to have an IME. But the judge said, look, I think this raises questions about the thoroughness and accuracy of the claims denial. Now, the other argument that Willard made was, look, this medical review that UNUM did was arbitrary and capricious. The court said, look, a file review can be arbitrary and capricious when there's significant objective evidence in the records that supports disability and the reviewer hasn't adequately considered the record. In this case, however, UNUM's liar-for-hire doctors had looked at the treating physician's opinions and ultimately decided that they were going to accept their own opinions and reject the opinions of the treating physician. Now, in this case, the judge said, no, I don't quite get that here, because I think that they have arbitrarily credited the filing, the reviewing doctor's opinions over the treating physicians, and they ignored the treating physician's opinions about getting the IME, and also ignored the treating physician's rebuttal of the peer review physician. They just sort of blew past it. So the judge said, look, I think that's arbitrary and capricious. The third thing that Willard argued was that, look, there's objective and subjective medical evidence that supports this claim. And the court agreed. Look, they said there was subjective medical evidence concerning the disability. There was positive physical testing. There were years of medical records documenting his chronic pain. There was the history of the treatment becoming less effective over time or providing only short periods of relief. And there was, on physical examination, a worsening of the range of motion of his hips and his spine. Now, in light of that evidence, the court said, look, it's arbitrary for UNUM to deny this claim without a physical examination to determine the severity of the symptoms and the extent of his disability. And so we agreed that that's arbitrary and capricious. The fourth thing that Willard argued was, look, the UNUM liar-for-hire doctors really made a credibility determination that's not supported by the evidence. The court said, we agree, and we agree that it was arbitrary and capricious in determining that Willard's subjective complaints were credible and rejecting the rationales for the treatment plan not changing as of the last date of work. The judge just didn't buy the fact that he had only been seen once in the last 6 months, that his symptoms were worsening, and that his ability to do work was inability to do work was not supported by the medical records. So The court took sort of a longer view of this case and looked at the medical records and said, look, this guy's been complaining of subjective complaints for years. His treatment plan has been implemented. It was effective over time. Its effectiveness declined. The frequency with which he was seeing the doctor hadn't necessarily changed. Clearly, his symptoms were worsening based on the description and the physical examination, and the inability to do the activities of daily living was irrelevant. And so the court said, look, again, you didn't have Willard examined, and you're relying on your doctor's liar for hire subjective analysis of these complaints. And ultimately, what the court did was agree with Willard that this denial was arbitrary and capricious. I want you to understand that disability carriers like UNUM and other disability carriers aren't in the business of paying benefits. They'll come up with these bogus reasons like you've worked the day before and nothing's changed, or there was no change in your symptoms when you stopped working. Your treatment was the same for years. What you do in your daily life is just what you do at work, or what you do in your daily life is inconsistent with what you told your doctor you could do. I see these reasons in denial letters every day. And they go on with even more ridiculous basis for claims denial. The bottom line, in my view, is that you deserve your ERISA disability insurance benefits. And if you get a denial letter like this, it's time for you to reach out to an experienced ERISA disability attorney and take on disability carriers like UNUM, who are in the business of denying claims and terminating benefits so that they can increase their bottom line at your expense. Let's take a break.